recall it.
I don't.
But, we did lost. But I tried to sell it again, and the park manager refused to let me sell my trailer. Because he said that other guy had a pending lawsuit against me. And so I went to trial for hearing, and he never showed up. I got dismissed, and I took the dismissal to the park manager and said, now I can sell my trailer, you know. So I went to the second hearing to be filed. And he didn't show up or again. And I took the second dismissal. He said it would check with his legal department. And he still didn't sell for them. And then I talked to the manager that he's above the park manager, operations manager, or district manager. And she said, well, you didn't sell your trailer. We don't. But after they said yes, they said I owe $7,500. You know, I could have sold it that month of November. The other guy backed out on the 31st of October, and I got plenty of people.
Okay, let me stop you, because this sounds like you're telling me your whole case in testimony. All right, well, you understand nothing you're saying right now is going to be used in my decision making because it's not evidence. It's just an open statement. Okay, all right. Anything else is by way of opening? Okay. Opening or reserve? Go ahead.
This is a case where the goalposts have been constantly moved. Mr. Clay filed an amended complaint April 29th of this year. We had at least one pretrial subsequent to that date. And at that time, I explicitly asked Mr. Clay whether he was going to stick with the allegations in the April 29th suit. Because those allegations superseded basically everything that he's just stated. The original lawsuit involved alleged interference with his right to sell the trailer. Claim delivery case has nothing to do with that. And Mr. Clay explicitly indicated that this was what he was going to rely.
Just to make sure in my memory, the amended complaint took it to a claim and delivery, correct? Okay, go ahead.
So anything above and beyond the allegations in the complaint, I would argue are irrelevant for this trial based on the acknowledgement Mr. Clay made in the pre-trial. Further, Your Honor, the eviction itself was completely proper. Pursuant to case number 24-6294 LT, which you also presided, a judgment of possession was entered in that case in favor of my client and against Mark Clay, who actually gave permission for his name to be signed. It was a consent judgment. That required all rent to be brought current by September 27, 2024. When the rent was not brought current, an order of eviction was submitted, which you entered on October 7, 2024. The eviction was then carried out. Now, the claim and delivery complaint claims damages for basically, I guess, the wrongful taking of certain property pursuant to the order of eviction. I would argue that Michigan case law is very clear and Michigan statutory authority is very clear that my client is immune from any damages because the items that were removed pursuant to the law of the issue.
Okay. All right. Thank you. All right. Ready to present your case? Okay. Do you have any witnesses or are you going to testify?
Yes.
Okay. Counsel, are you all right if he just stays where he's at after I swear him in? Are you okay if he stays there to testify instead of? Yeah, and you'll let me know if you're not picking him up. He seems to be loud. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth today? All right. So give me your testimony.
Well, testimony is, I took over the trailer from me and name on my pathways.
But let's get to the point where you file a claim of delivery saying that they owe you money for property. So let's get to that.
I spoke with them and some law firm that helps people.
Okay.
He told me about the claim delivery, but I had no idea about that.
Okay.
And, they took my property from my trailer, but they had no right to enter my trailer under Michigan law. I guess what it is. Says they cannot damage the property. Your property stays yours. If they say they did it under Michigan law, they didn't do it under Michigan mobile home law. It says they cannot damage my property or take my property. Maybe later when the cost occurred, I had it all paid up. They just let me sell my trailer and this would have been done long ago.
Okay, so what property was damaged?
Fifty pack of my company. They loaded everything in the trailer. Into three trailers, in my mobile home, into three trailers, took them to the landfill. On the 23rd of October of 2024. And they had no right to enter my trailer. They had the right to evict my brother. And, but they didn't have no right to take his property or my property because that's my trailer. That, they say that you signed an order saying they can do that, but I don't see how you can really do that.
I didn't sign an order that said they could take personal property out of the trailer and put it to the dump.
But that's what they said in a little meeting we had. The judge signed the order certificate. I don't think that unless they put a fraud on the order saying that it was their trailer or something. But, yeah, that's my case about my claim and.
Okay, but you understand with the claim and deliver, you have to establish value of the property and exactly what the property is and so on and so forth. Because a claim and delivery is saying, Judge, I want my stuff or I want the value for my stuff.
I got it in my filing.
In your what? I'm sorry?
Filing.
Your filing is not evidence. Your filing is not evidence. I make decisions at trial based on evidence. So you have to present the evidence today if you want me to consider that in my judgment. You understand what I'm saying?
I mean, but I can.
I don't know what to tell you. You've chosen to get into this arena without counsel. It's not fair for me to try your case for you and leave him to defend himself or his company. I can't help you present your case. All right. So I'm going on a limb when I tell you what you're supposed to be doing right now is establishing the items and the value for those items if you want me to give you a judgment of money for the missing items.
All right, well, I have some tools. Do you want it written down? How would you like this?
Once again, I can't tell you how to present your case to me.
I have some tools that were missing, that were taken out of my shed and my home. I would value them at about $7,500. It was taken. And they took my dad's flag, his military flag, which I considered that because that was in a box in the house. And they took about, I put it down $10,000. They took about $30,000 fishing tackle. But I used to be on.
Well, my limit is $25,000.
Yeah.
Right.
And then they took some furniture, couch, and some clothing. That's what I put down there as the amount. I know. Okay,
but once again, your filings aren't part of today's record at trial. So you keep saying, I put it down there, I put it down there. You've got to talk about it today as sworn testimony.
$3,000 worth of small appliances they took out. And probably about $1,000 worth of clothes. And my dad's flag and some living furniture, which was about $1,200, I can say. That's my personal property.
All right, anything else at this time?
I would just like to say that I don't feel they filed a claim against me for the rent. I don't feel
Let me stop you. That's not up today, is it? Did you counterclaim for rent? Okay. All right. Go ahead.
Okay. Once the manager told me I didn't sell my trailer, I just figured the rent wasn't due. I never got a bill on that rent, and I still haven't got a bill for rent. Anything. Like I said, it just kept adding up. They never sent me any kind of invoice. They never signed anything with the park saying I had to pay the rent. I just wanted to sell my trailer and get out of the deal. That's all I wanted to do.
Did you ever sign any kind of lease with them? Anything else?
I got my witnesses.
Okay, well, once again, it's your case to present. You decide how to present your witnesses. Come on up, sir. No, hold on. Stay where you're at. Would you like to cross-examine this, Mr. Clay? Go ahead.
Yeah, any documentation we do today of the values of these items that you claim.
Right.
You have no independent verification. Okay. So basically, the court simply had to take your word for it as found as far as valuation.
Yes.
Okay. The fishing tackle, when did you buy it?
I started fishing in, a lot of the old stuff, early as 1990 up until, 2010.
So you used it obviously often during that period of time.
Yes.
So it's depreciated, correct? Not only so, you're guessing that it didn't. The tools also were used.
Yes.
Okay, so again, could have depreciated. Your dad's flag, is your dad still alive?
No.
Was there a probate estate?
Open. I know.
Were you ever appointed personal representative of the estate?
Yes. Well, my mother.
Your mother. Okay, so your mother would be entitled to act under the estate.
Correct. My mother was dead when the flag disappeared, so that was mine.
Right, did you open a probate estate for your mother?
No.
Okay, so there's no court order that permitted you to act on behalf of your mother's estate or your father's estate.
Well, I inherited all my stuff from my mother, so I guess the flag is mine.
Couch, clothing, again, depreciate, all used.
Yes.
And small appliances used, clothing used.
Yes.
And you don't have any valuations today of any of these items.
No.
Okay, including or not including depreciation.
Right.
You do not dispute that a judgment of possession was entered by Judge Oakley against your brother on September 13th, 2024.
I don't know what day it was. It was one around there.
No. Go ahead and get that. Our missing exhibit. I'm ready to move out. Oh,
Taylor,
You'll copy the document, not the defendant's proposed exhibit 1, and ask you if that is, to the best of your knowledge, the judgment of possession was entered in the case against your brother.
Yes. That's
And,
fine.
okay, and it was approved by Judge Oakley, if you look at it, September 13, 2024.
Yes.
And it provides that the sum of $1,491.46 has to be paid by September 27th. Is that correct?
Yes.
That's paragraph 4. Is. And if it's not paid, then my client would have the right to apply for an order to fix your gross.
Yes.
Okay. Now, was that going to be paid by September 27th? When it was been marked, or was going to be marked as finished proposed exhibit 2, and ask if you can identify.
What was that?
All right. I'm giving you what's been marked as defendant's proposed exhibit 2, correct?
Yes. Yes.
All right, and that is an order of eviction that was approved also by Judge Oakley, correct?
Yes.
And that order of eviction provides that my client is entitled to be brought to immediate possession of the premises, correct? The property. The immediate possession of the property. Yeah. So, based on what you were told by an attorney whose name you disclosed, it is your belief that my client did not have the right to remove anything from that trailer. That's correct.
I'll take judicial notice of that fact.
There's law that says otherwise.
I'd like to see it. Trailer wasn't yours.
I will, I provided Bill a copy of the,
Love to see it.
so I guess the question that I have for you, well, I won't even ask it because the case law speaks for itself and I'll pull it to the law. The order of eviction was carried out, correct? Yes. A court officer pursuant to the order of eviction. Yes. That's it is not representatives of Park Estates that came in. Okay. Well, they court officer was entitled.
The court officer works for the plaintiff in an eviction counsel. You know that.
Well, but the order of eviction instructs the court officer to restore the plaintiff possession.
Of the lot. Of the lot.
I'll respectfully disagree with the court based on the case law that I think we have.
Okay.
Now, your brother signed the lease for a lot.
Yeah.
You know, so. So it's your testimony that nobody signed the lease for a lot?
My dad signed an application for when the other company was the owner of the trailer park. I don't know what they're called, maybe,
But your brother signed the judgment. Approved the judgment for entry, correct?
for the eviction.
Yeah.
Yeah, I guess, okay. I was there.
Was your brother living there?
Yes.
He was. And this was not the first case that was brought against him for eviction, correct?
I believe it was.
There was not another case that was filed in April of 2024.
That's what I know.
Might nothing further, John.
Okay. Okay, so I'm gonna take that. You testified as direct. This was crossed. Do you have anything now under redirect, or you want to put your brother on the stand? Come on up, Mr. Clay. The other Mr. Clay. Raise your right hand for me. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth today? Come on up here and have a seat. Your first name is Mark?
Right here.
Yeah, right there. Settle in that chair. All right. Plaintiff, Mr. Clay, you can ask questions of witness, Mr. Clay. Go ahead.
The first week of November, seventh grade, I don't recall the date. Did I ask you to come in and listen to a phone call between me and Eddie?
Yes, you did.
And you recall what Eddie said?
You can actually hear it because it was under oral support. It was something to do with the
Awesome.
Your Honor, I'll object on the basis of relevance. Once again, this has nothing to do with the claim delivery. It has to do with the original complaint that Mr. Clay filed, which was superseded by his own admission.
So claim and delivery is, you're saying they took your stuff, you want your stuff back. If they can't give you your stuff, you want the value for the stuff. So how was that phone call? Who's Dave, by the way?
Yeah.
All right. How is the phone call between you and Dave relevant to that? Okay, move on.
Did the court officers empty our trailer?
yes, they did.
Everything.
Everything.
And the shed. That give it after description of my property.
Yes, very good. Yes.
And you lost property.
I lost about $40,000 myself.
And are you gonna file a lawsuit?
Yeah.
That's all I have to say, Mr. Rankin.
That's
Hold on. There's no question, no answer. Cross?
Mr. Clay, you approved the entry of the judgment of possession. That was exhibit 1. Show it to me.
I know.
So yes or no questions? You approved it for entry.
Yes.
And you didn't pay the rent.
Correct. Yes.
And therefore, there was an order of eviction that was issued by the court and carried out.
Yes.
Nothing further.
Okay. Any redirect of Mark?
Well, did you feel you was under arrest by, you had to let them people in?
Yes.
That's all you're gonna.
Any recross?
There was a court order that made it down to effectuate the eviction. True?
Yeah, you're right.
What's your objection? What's your objection?
Well, it's stating, court order said they can enter, basically what he said, he's gonna show us the case law, we've seen that yet, so I don't think that's any proper question.
I think to put it in legal terminology, that would be lack of foundation.
I'm not sure necessarily law has a lack of foundation, but let me see if I can establish. Mr. Clay, there was a judgment entered, you didn't pay the judgment, correct? Correct. And the judgment provided that Park Estates could request and have issued an order of eviction if you didn't pay the judgment. Sure. And you didn't pay the judgment, so they requested an order of eviction. And that order of eviction was carried out. Nothing to it.
All right, you can step down. Any other witnesses? Ms. Arnold, come on up. Raise your right hand for me. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth today? Come on up and have a seat in this chair. When you're ready.
You were there on the day of the eviction,
Yes,
you seen them court officers carry out all the property,
yes,
and they left nothing.
they left absolutely nothing on them.
That's all I had to know. She don't know about stuff, but I do.
Okay. Cross?
You have no idea of the value of any of these items that were in the home.
Some of them I do because it was my kids' items that were there too.
Do you have receipts or anything to establish the value with you today?
I don't have nothing because they took it all out.
But Mr. Clay seems to have given estimates of what he believes the value would be without, again, any established receipts or anything to show documentation. You have no documentation of your day item, correct?
No, because
And
it
you
was
also haven't brought a suit. Did you give any kind of authority in writing for Mr. Clay to pursue a lawsuit on your behalf?
not in writing.
All right, Mr. Clay's not an attorney, is he?
No,
So he's not your legal representative today?
no.
Nothing further.
Any regret? You can step down, ma'am. All right. Plaintiff, Mr. Clay, anything further at this time? Counsel?
Your Honor, defendant moves for a directed verdict based on Brown versus Real Estate Management Specialists, 2021 Court of Appeals case.
You have a copy for him.
I'm going to quote directly from that decision. Plaintiff argues that defendants operated outside the scope of the eviction because they were not entitled to enter plaintiff's home, remove her personal property, and dispose of it in a trailer. We, the Court of Appeals, disagree. The possession judgment advised plaintiff that she had to pay $3,519 by May 14, 2018, or leave the premises. It also advised that an order of immediate eviction could occur for the failure to comply, and that partial payment was insufficient to stop the eviction, which, by the way, is what the judgment provides in this case. And that he provided in Exhibit 1. It is difficult to discern how plaintiff believes that she could be compelled to leave the premises, but allow the possessions to remain. Indeed, the judgment granted possession to the plaintiff or the defendant in that case. And the order of eviction directed the court officer to restore the plaintiff to and put the plaintiff in full possession of the premises, which is exactly what the order of eviction states in this case. To state that REMS, which is the plaintiff in that case, would be granted possession of the property, obtain the right to evict a person, but would not permit the removal of the person's belongings, would deprive REMS of the use of its property. After a lease is forfeited for non-payment of rent, the landlord may obtain lawful possession and forcibly remove personal property which does not constitute a breach of the peace. There is no indication that plaintiff attempted to negotiate with counsel for REMS for a date certain to remove her belongings, despite previous negotiations. This claim of error has no merit.
What were the premises in Brown?
It's clear.
Who owned it?
It was owned by, well, it was leased to Brown, who was the plaintiff in the case. She's the one that was claiming damages for the removal of the property. REMS, the defendant in that case, was was the party that obtained the order of eviction,
Okay, at one point you said REMF was plaintiff. That confused me.
but it was plaintiff in the eviction case.
I'm sorry, plaintiff in,
The eviction case, I apologize. So that's word for word quoted from the opinion. I will provide you a copy.
He said one thing here.
Now,
hold on. Not your turn yet.
it's not the only case that provides community for carrying out an order of eviction. I would also refer the court to Terminal Ministries versus Bank of America, also a court of appeals case decided in 2011. And the landmark case in that area is a case called Sickles, Sickales, from 2007. Barnaby versus PCI also is on point. That case is a 2015 court of appeals case. There's no question that my client and the court officer are entitled to immunity. It's statutory immunity, and I will cite the statute. It's NCL 600.2918 is the applicable statute.
2918.
Yes, providing for it. So, combination of all these cases together plus the statute, I would submit that my client had the absolute right to remove Mr. Clay's belongings from the home, and therefore, on that basis, my client would be entitled to the directed verdict. Further, Mr. Clay has failed to meet his obligations with respect to the claim and delivery claim. He has not provided this court with any kind of documentation relating to the value of these various items that he claims were wrongfully removed. Some of which go back more than 20 years and certainly have appreciated over the course of time. Mr. Clay provided nothing in terms of how the items were obtained, provided nothing in terms of who purchased them, what the purchase price was, and any kind of appreciation for it. So, therefore, he has not met his burden with respect to claim and delivery claim either. Under either or both of those theories, my client would be entitled to a direct verdict.
Response.
In his first one, he said that it was a lease trailer. In this thing, so the lease trailer should have come up. Even that state said it was a gray area that I let them get bought.
Let me stop you. I took it from your explanation of ownership on the Brown case that Brown was leasing from a third party, not from REMF.
I don't believe that's the case,
Okay.
but I will let me clarify.
Sure.
She leased the home from a private landlord. REMS was the management company.
For who?
For the-
Yeah, so she was being evicted by the owner of the trailer. That's not on point with this case. And it's disingenuous for you to imply to the court that it is.
I disagree, Your Honor.
How do you disagree? It's a different owner of the trailer. Owners have different rights than the park owner of a lot.
Your Honor.
The person that owned the trailer Brown was living in had Brown evicted, and as part of that eviction, she lost personal property. That's the same as an eviction on an apartment or a single-family residence. There's a complete body of statutory law dealing with evictions of mobile homes that's not there.
So the termination of tenancy case, Your Honor, they would have had 90 days to sell the home. This was not a termination.
But my point is you're presenting Brown as if it's analogous to our situation here, and it's not. It's a completely different fact situation. Well, guess what? I'm wearing the black robe and I say it's not. So Brown is not in my decision-making today. So if you've got something that's analogous to this fact situation where you were evicting a trailer off the lot that you own, but you had no ownership interest in the trailer, then I'd love to see that case law.
The Turner case, Your Honor, once again, is a claim that there was wrongful in storage of personal property.
Let's start with who did the eviction and who owned the trailer. Go on.
Once again, there was a claim that there was a wrongful removal of property, that was taken to a storage facility. The court held that the removal was proper.
But who owned the trailer?
It was foreclosed upon by Bank of America.
Okay, so Bank of America was the owner.
It wasn't foreclosed, I agree.
Yeah, but they owned it. At the time of the eviction, Bank of America owned title to the trailer, correct?
Yeah.
Who was evicted?
The purchaser.
By Bank of America, the owner. So once again, totally different fact situation than Clay versus Park Estates.
Finally, in Barnaby versus PCI, it also is an order of eviction. And the funding was that
Don't tell me the claim. Who was the plaintiff in the eviction?
was the landlord.
The owner of the unit.
I don't believe so, but let me.
Well, if they were the landlord, if they weren't the owner of the unit, how were they the landlord?
Because they leased the.
So they were acting on the auspices of the owner. I lease it from Clay. Clay rents it to Landman. That means Clay's the owner for eviction purposes.
I don't, I understand what the court is saying. I don't believe that it is separate and distinct because of the fact that you have an order of eviction.
My eviction authorizes the court officer to get a trailer off your lot, not to go in and dump all the property to the dump. Never in my tenure on the court have I said to the court officer, go ahead, take personal property out of a trailer that the plaintiff does not own and throw it away. That's not what my eviction orders are meant to do.
The eviction order, and in this case, in the case that I provided, and in all three of these Court of Appeals cases, instructs the court officer.
Counsel, you're not catching what I'm laying down here.
I know exactly.
Your client did not own the trailer that the eviction took place at. So all those case laws, the evicting party owned the trailer. You're talking apples and pork chops. We're not even all in the same fruit basket here. So I hope you do. I hope you appeal it. So let's talk about your other reason for the directed verdict. What statutory or court rule authority do you have that I can't take testimony alone on value?
Testimony, Your Honor. It's got to be supported.
Where's that at? I'm asking you for the court rule.
Claim would have raised is 3.1. I think it's 3215.
Take your time. Sure, counsel, take your time. Mr. Clay is going to go get a drink. No, he wants a break to get a drink. Go. Just don't talk while he's out of the room.
Your Honor, the court rule is 3.105. 3105C2
Hold on a minute. Okay, I didn't know he was back yet. All right, go ahead.
requires that the value be stated.
I'm sorry, counsel, 3.105. What? Right.
3.105C2 requires that a complaint state the value of the property. which is not an admission of value. So therefore, in order to establish value, the proofs have to establish. You have estimate from Mr. Clay, you don't have any supporting documentation whatsoever. Yeah.
Okay, anything else?
Think your foundation for value to consider all.
Once again, I can't tell you how to present your case, but you don't have to have original receipts to establish value.
So,
I said original receipts for purchase is not the only way you can establish value of an item to the court. Anything else? Okay. All right, counsel, grant your motion. Let's move on to the counterclaim.
Your Honor, as I look at the counterclaim, the judgment was against Mark Clay. So I do not believe that George Clay would step into Mark Clay's shoes. So with that in mind, if Mark Clay decides to file a lawsuit, we will go ahead and pursue a counterclaim against Mark Clay.
I think that means you're dismissing your counterclaim. You're right. I'm sorry? Any objection to the trailer being sold?
If the trailer is titled in George Clay's name,
Who's got the title? All right. So I'm just hearing that that's the only worry they.
well, $16,000 they say that rent. And that's why they have.
Okay, well, he just admitted you don't owe any rent. He just said he's letting his counterclaim go because you're not the responsible party for back rent.
See that? Okay.
That's what I just heard.
I'm not letting it.
Okay. All right.
future litigation. But I suppose if that occurs, then we'll have the issue of whether there are claims that should have been claimed here. Because maybe it's a claim.
I don't like to talk about how many angels can dance on the head of the pin. So if it comes up, we'll deal with it then. All right. Questions?
Well, that, tell Parker State that I can only rent and I can sell my friend.
There's rent for the lot.
Which has nothing to do with the trailer. Would you agree?
Doesn't have anything to do with purchase price. Home's been sitting on the lot for now several years.
Because you wouldn't let him sell it. Your client told him they couldn't sell it. So now you're telling me they can refuse to let him sell it and then say he can't sell it now because the lot has too much back rent on it? Then we're going to be back here for another claim of delivery because you've forcefully taken the trailer.
Well, I don't believe you're going to file our own claim of delivery. That has to be.
No, my point is you can't, on the one hand, you can't say, sure, go sell your trailer. And on the other hand, say, but you can't sell it now because there's too much money owed on the rent and somebody's got to pay us that. You can't stop him from selling the trailer and then hold him responsible for the lost time. So the man needs some direction. Are you authorized to tell him, put it up for sale and get it out of there?
The authorization to try the case based on claim delivery of the spot.
What about your penalty?
He just dismissed that.
Hold it back, right?
Yeah, but he just dismissed it.
Okay, but.
And I can't stop him from dismissing his case. Right. So I think what I'm hearing from him is you got to sue Park Estates because they've taken your trailer. Have they deprived you of its use and value?
Yes,
That's a taking.
and they have, last year, they made the local office.
You got to go see a lawyer, Mr. Clay. You got to go see a lawyer. Because a lawyer would have walked out of here with a judgment against them today for claim of delivery. And I know it's throwing good money after bad, but good luck. Have a nice day.
Or the judgment about anti-IP.
Yeah, I think, Carly, we got to e-file that judgment, don't we?
Yes, Judge.
Yeah. Thank you, Mr. Lambert.